Hello and welcome to Connected with Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. I am Andrew Moyle, a data and technology transactions partner based in London. This podcast is the second in a series of 3 considering the impact of the new Corporate Insolvency and Governance Act in the UK, as well as existing insolvency-related regimes in the UK and the US on commercial contracts. In the first episode, our colleagues from Latham's Restructuring and Special Situations practice gave us an overview of the new Insolvency Act and the treatment of ipso facto clauses, which historically allowed parties to terminate commercial contracts on the grounds of insolvency. By way of quick recap, under the new Act, these clauses in contracts for supplies of goods or services will be unenforceable when the other party enters into an insolvency process. In this episode, we are discussing the practical application of the UK and US insolvency regimes with respect to commercial agreements and the way in which you can protect key contractual arrangements in the event of financial distress. I'm joined by my fellow Latham partner, Christian McDermott, and my colleagues associates Kristy Watkins, also based in our London office, and Morgan Brubaker from our Washington, D.C. office. Let's start this discussion by setting out some of the risks that could arise when a counterparty to one of your material contracts is in financial distress. Morgan, if you are a customer, what are the warning signs that you should look out for?
Thanks, Andrew. There are a number of warning signs that could alert a customer to the potential financial distress of one of their suppliers or vendors. Some of these are obvious and some of them are more subtle. Many times, the first potential sign of financial trouble is that a supplier or a vendor begins having performance issues. This can manifest in a number of different ways depending on the industry. Material suppliers could be struggling to continue supplying their usual goods or products on the same timeline, or there could be a change in the quality of the product being provided. With respect to IT vendors or service providers, they could become less responsive in providing services and begin failing to meet their contractual commitments regarding service levels. Another potential indicator of financial distress is when a supplier or vendor may try to raise prices or accelerate payment terms, even if they don't necessarily have the right to under a contract. For example, a customer may start getting calls from a distressed supplier or vendor asking for early payment of amounts due or offering the customer a discount for early payment. A customer may also abruptly see higher prices on their invoices without warning or explanation. On the flip side of this, suppliers or vendors may also start seeking increasingly creative ways to avoid incurring costs. This may manifest through delay tactics with respect to performance, strained contractual arguments, and revisiting previous informal compromises, all of which could have an impact on day-to-day operations and increase the time and effort required by the customer to manage the contractual relationship. Suppliers and vendors could also claim a force majeure event, meaning that they advise their customers that they are unable to perform under their contract due to unforeseeable circumstances outside their control.
Right, and we've seen claims for force majeure really increase with the ongoing COVID crisis, and in fact, it's a subject of one of our earlier podcasts. So force majeure can sometimes be a precursor to a supplier ultimately going into bankruptcy or insolvency proceedings.
Absolutely. We recently had a client in the medical diagnostics industry who had a key supplier claim a force majeure due to COVID-19. That supplier simply couldn't put in place a workaround quickly enough to be able to supply the materials to the client in a timely manner, and our client ultimately had to seek an alternative source of supply. By the time the supplier was able to resume operations, our client, along with many of the supplier's other customers, had all gone elsewhere to procure the goods, and the supplier filed for bankruptcy. Lastly, customers will want to be on the lookout for other warning signs, which may be visible in the market, the news, or based on other publicly available information. These could include delayed or restated audited financial statements, changes in debt structure such as new loans, extensions, and modifications of existing loans, or deteriorating market position, including lawsuits or warranty demands. Again, none of these, in and of themselves, necessarily means a supplier or vendor will go into bankruptcy, but they could be indicative of financial distress.
Thanks, Morgan. That's a great summary from a customer perspective. Maybe what we should do is flip the coin and look at it from a supplier's perspective. And Christian, what sort of warning signs might suggest, for example, that a key customer is in financial distress behind the scenes?
Thanks, Andrew. So, I think a lot of the points that Morgan just mentioned will really apply equally to customers as well as they do to suppliers. And by and large, suppliers will already be fairly experienced at spotting customers who are in financial distress. So it shouldn't come as news to them that late or missed invoice payments could hint at cash flow issues behind the scenes. Other things that I'd suggest suppliers look out for are, for example, unusually rigorous checks being applied to invoices, maybe in combination with a reliance by the customer on technicalities to avoid payments. Linked to that, suppliers might also experience additional requests for discounts or see customers going after monetary claims that they wouldn't normally pursue. Another concerning sign might be customers seeking scope reductions or cancelling projects. And finally, I'd also be a wee bit concerned if customers stop or significantly reduce their communications with suppliers, as that could hint that they're dealing with more pressing matters behind the scenes. Now, as Morgan already said as well, I should stress here that there could be perfectly good explanations for all of these things, but if suppliers start seeing combinations of them, they might want to start considering their options.
Right. That's all fair enough, Christian. Thank you. So I was always taught that prevention was better than the cure. Let's turn back the clock, as it were. And Kirsty, what mitigations, though, could you put in place to protect against risk arising from a counterparty being in financial distress further down the line? What can be done when acting for suppliers or customers in this instance?
So the first thing to do, Andrew, is to ensure that you conduct proper due diligence on your counterparty in the first instance, whether you're a customer or a supplier. So this could mean investigating potential supply chains, developing good understanding of where there are some complexities and where potential issues may arise, and focusing on potential points of failure in the industry that you're looking at. So, there are lots of different things you can do. Look into the history of the relevant counterparty, the history of their service provision, whether they've had any past or recent reorganizations, for example. You might, as a customer, get some references from other customers in terms of what their experience has been. And there are many things that you can do to try and see what you can find out right up front as to whether this could potentially be a risk. Another thing you can do is think about what potential and applicable insolvency regimes would apply in your jurisdiction as part of the procurement process, particularly if you're in a regulated industry like financial services. Then there are particular requirements you have in Europe, for example, under the EBA guidelines, where you need to consider these things right at the start.
That's absolutely right, Kirsty. I'll say that you shouldn't underestimate the importance of having robust governance regime in place with regular reporting and meeting obligations, particularly when you are a customer in a material supply agreement. Having frequent and open dialogue with the supplier or vendor and actively managing the relationship will give you insight into the operations and financial condition of the supplier and vendor. And you can hopefully find out, if anything has changed since you did that initial due diligence, and then that might give you some indication of things to come, or if there might be some intermediary action that could be taken in the case that you do notice a difference between their standing when the contract is in place versus when you first did that due diligence. And if you're lucky enough to be just building your contract now and thinking through all this, you could even build in further thresholds and milestones into your contract based on the financial information of the counterparty that you receive during due diligence. Depending on your commercial leverage in the relationship, you could include step-in rights or notification obligations when certain financial thresholds are reached. And these would serve as precursors to bankruptcy or termination so that you might be able to take steps before you get to bankruptcy. Example of these thresholds could be an external auditor giving the counterparty a going concern explanation or qualification, the common stock of the counterparty becoming delisted from a national securities exchange, the counterparty defaulting or otherwise materially breaching any of its material debt obligations, or other similar thresholds.
I think that's really sensible advice. And I think trying to build on that purely from a financial perspective, counterparties might want to think about a parent company guarantee or PCG. That may be also useful for both suppliers and customers alike, particularly if there are concerns around about a specific member of a larger corporate group. PCGs can be particularly useful where a small entity with a relatively light balance sheet is part of a large, well-capitalized group. The guarantee would be given by the parent company to the counterparty, and in the event that the subsidiary defaults on its obligations, the parent can be required to perform or procure the performance of its subsidiary's obligations under the contract. That would be a performance guarantee. Or the parent could simply be liable to pay the counterparty damages in respect to the breach. That would be known as a payment guarantee. Whether parties decide on a performance or payment guarantee really, I think, depends on the importance of actual performance to the counterparty and whether the parent, is actually in a position to perform the subject matter of the contract itself. And if something like a PCG isn't suitable for whatever reason, it's also open to parties to explore other forms of security. For example, a performance bond, under which the issuer of the bond, normally a bank, would undertake to pay a sum of money to the counterparty if there's a failure to deliver goods or perform contractual services on time or otherwise in accordance with the terms of the contract. The downside with performance bonds is that they can be very expensive, so they tend not to be used a lot on technology projects, but I guess they're worth considering at the outset.
Right. So I am also, I guess, interested. Have you guys seen anything more bespoke in your experience? A bit, Morgan, what about you?
Well, in thinking about certain specific sectors, like, for instance, the semiconductor industry, what often happens is a customer will seek to obtain a supply authorization letter from their manufacturer. And this is a type of letter that basically ensures that a customer would have the ability to contract with someone else to manufacture their chip in the event of an insolvency or bankruptcy of the manufacturer. And this is important because oftentimes, and especially in the semiconductor industry, a manufacturer's proprietary IP is required for the production of the product. So this would allow a customer to take actions with respect to their product without relying on or waiting for bankruptcy proceedings. So it can, allow them to have continuity of supply without having to worry about a court, allowing them or forcing the supplier to continue to produce their product.
And just looking at materials, software, and IT agreements, we see a lot of source code escrow provisions. So they're certainly something to think about. And what these are is it's an agreement to deposit the source code of critical software with a third-party escrow agent, and the parties would enter into a separate agreement alongside the software license agreement, where it's requested that the source code for the relevant software is deposited into escrow with a third party, only to be released upon a defaulting event. And these are heavily negotiated, but they can include certain insolvency events, changes of control, or where a party, for example, ceases carrying on the relevant business. They're usually very tightly defined. And the point is that a software license agreement usually just conveys access to the object code, so not the source code. You actually need to run the product. So in these cases, if one of these events occurred, the source code would become released to the licensee by the escrow agent. There are some pitfalls here in terms of the code that the escrow agent has might not necessarily be kept up to date. So it's really critical to make sure that regular updates are made throughout the term of the license agreement. And also, just practically, the licensee might not have sufficient in-house experience to be able to actually operate the code even when it is released. So ways of getting around this usually involve testing upfront when you enter into the escrow agreement to make sure that a third party would be able to operate the source code and software without the expertise, or can make sure that they can use it. But they can be quite expensive, those testing services. But obviously, where it is critical software and there's potential risk of an insolvent licensor, then that's something you could consider.
Thanks, Kirsty. So let's just change tack for a moment. And what I want to do is move into the performance of the contract. So once you're in a contract, what are the provisions that can be leveraged to protect a contracting party's interest and to make sure that you get as much warning as possible of any imminent danger?
Morgan touched on some of this before, but governance mechanisms are really important here. And often you might have some wide governance rights, but it's also a matter of making sure that you use them. So the more frequently meetings are held, where things like financial health are regularly tabled, is helpful, no matter which level of meeting that's at. You can also consider leveraging existing audit or inspection rights. So there's you might have an audit right to check documents in relation to performance of the services, and you could try and leverage some of these to receive financial information. You might also have rights to obtain reports, so you could see if any of your reports might include information that would suggest that there's any financial difficulties. And in the US in particular, SEC filings can be monitored publicly. These can function as additional indicators. And of course, it's always a good idea to keep an eye on your material counterparties just in the media. I mean, ideally, that's not where you'll first find out if there's a problem, but it certainly can happen. And it's definitely something you should be across with your material suppliers and customers.
I agree. And I think in an ideal world, governance and monitoring would be all that you need. Unfortunately, however, there'll also be scenarios in which termination rights need to be carefully considered. And as you mentioned at the top of the podcast, Andrew, in our previous episode, we talked about ipso facto clauses, the clauses that allow one party to terminate due to the other party's insolvency, and talked about the fact that those may be unenforceable now under English law following the new Corporate Insolvency and Governance Act 2020. However, I'd remind our listeners that there's a wide carve-out for businesses in the financial services sector, so they should be aware of that. It's also worth considering common law termination rights in this context, as they're not specifically addressed in the new Act. Under English common law, any contracting party can terminate on the grounds of a most serious breach. It's generally referred to as a repudiatory breach. And although the position isn't completely settled, the general consensus seems to be that these rights are still likely to apply, notwithstanding the new Act. However, I'd also stress that it remains open to contracting parties to exclude common law termination rights by including clear wording in their contract to that effect. So, for example, common law termination rights won't apply if there's already a statement in the contract, for example, that the party's only rights to terminate are as set out in the termination clause. So if there's an overall message here, it's to get into the detail of potential ways out of the contract and also what that might mean in practice. So, for example, what kind of assistance might be required on exit? What assistance is the counterparty actually obliged to provide under the contract? And does that match what's going to be required in practice? And then finally, what are you actually likely to receive in practice from an insolvent counterparty? I think these are the practical matters that parties need to think about.
Yeah, and I guess, I mean, termination for in many circumstances is really the act of last resort. And I guess that before you press the nuclear button, is there nothing else that you could consider before we have to go to the point of termination?
That's definitely right, Andrew. Certainly, termination is a bit drastic and isn't usually a good outcome for either party. So, there are, of course, a few steps before termination of a contract that could be useful to consider. So, if you've implemented a strong governance process, as we've continued to discuss throughout this podcast, working with the supplier or vendor to implement changes to either the operational processes, the payment terms, or the legal contract can sometimes be beneficial to both parties in order to avoid termination. Suspension clauses can sometimes be useful where the provision of services can be suspended for a finite period of time prior to the exercise of any termination rights. And so this would allow the customer to, seek a second supplier or vendor, or, have someone else perform the services to give the supplier a bit more time to, figure out what's going on and maybe resume the services. Step-in provisions are also another alternative, and this is where a supplier is unable to perform, and so the customer can actually step in to provide the services themselves, or have another third party come in to perform the services on their behalf until the supplier can, again, resume its performance in accordance with the contract.
So, call me a cynic, but how easy is it in practical terms to make a step-in rights clause work? Because I think there's a lot of people out there that would say that, practically speaking, it's difficult.
It really will depend on the nature of the relevant services in terms of how easy or difficult it is to apply these rights. I mean, often in large material services agreements, it will be very difficult to find someone externally or even have the in-house expertise to jump in and take over a supplier's position, especially in the midst of a supplier having provided an established set of services on over a long period of time. Not to mention that, the waters can be muddied into any existing disputes or potential disputes if the customer themselves tries to take responsibility for performing some of the services.
Well, I guess what I'm saying is what if it's already too late by this point? And I guess more fundamentally, what if you don't have those rights, step-in rights, built into your contract? What can you do?
I would say the first thing you should do is pick up the phone to a good lawyer at Latham & Watkins. We should be able to help you leverage whatever tools you do have in the existing contract. Otherwise, from a customer's perspective, I think you'd want to be exploring options around about backups or second sources of supply, because they're independent of whatever your contract says. And also think about how your existing BCDR, so it's business continuity and disaster recovery, how that BCDR strategy can be leveraged to help here.
I couldn't agree more, Christian. By the time you actually enter formal bankruptcy proceedings, whether you're on the customer side or the vendor side, your rights, especially in the US, are very limited. So, what we would advise doing is, setting yourself up to be in the best position, whether it's you've already executed a contract and you sort of want to look at your existing contract and, see what you can do from a contractual perspective, or from an operational perspective to help put you in the best place you can. Or if you're negotiating a new contract and want help thinking through all these things, you just want to make sure that you're in the best place in either of those situations to know what your legal and operational strategies will be if you have, if a bankruptcy occurs from a key supplier or key customer.
Okay, well, thanks, Morgan, and I'm going to have to draw a line under it there. But also thanks to Christian and to Kristy. Really interesting topic, and obviously very, very relevant given the times that we're currently, unfortunately, in. So I just want to thank everybody out there for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or anywhere else you listen to podcasts. If you'd like more information about the topics in this podcast, then please email us from the links located in the show's description. We hope you join us again next time. Goodbye.
This podcast is provided as a service of Latham & Watkins, LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins, LLP, and you should not send confidential information to Latham & Watkins, LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins, LLP, 885 3rd Avenue, New York, 10022-4834. Phone number 1-212-906-1200.